what I need to be very clear about is there are certain rules for this session which we have to follow. So all those who can listen to me carefully, be advised that in event of in between the session, if there is any technical kind of a flaw which you may face, there is a number which you may have to write down. So you may please write it down that in case if you are facing with any kind of a technical difficulty, this is the number which you have to call. You getting it? So kindly write down that number, which I'm just going to tell you, because one of the most prominent rule which we're going to follow today is that between the session I'm not going to take any kind of a question. Okay, so the last 15 to 20 minutes to even if the questions are there, the 1 hour specifically at the end of it, I'll give it to you for your questions. So in between, I don't want you to keep popping questions, because that disturbs the other students. Now we are telling you these things because of the feedback which we have received out of the last session. You getting it? So if there's a technical kind of a problem that you're going to face, this is the number you need to call. Rather than disturbing the entire class, what you can do is you can call on this number. Okay, so the number goes like this: 783. You may like to write it down: 783 88 61 605. Okay, 783 88 61 605. Okay, so in case in amidst the session, if you are finding any kind of a technical problem, this is exactly the number which you have to call. Okay, so the sir has also shared the number with you. So in case of any kind of a problem, you can directly call us. We'll begin with the session. One of the prominent rule I'll again repeat which you have to follow is that in case of any doubt which you have, what you can do is you can keep a pen and a paper in your hand. You can write down that. Okay, at the end of the session, I'm not going to leave the session unless and until I have not solved all your doubts. Is that clear? Okay, now when asking your doubt, also be very specific about your doubt. Like in the last class, I had a person who, a student who was asking very vaguely, and when you're asking me a doubt, make sure that the doubt is in a single message. Because if you write one line and then take a pause, there will be 3 to 4 students who will ask questions. So there is no kind of a continuity in your question. So that should not happen here. Now, one of other feedback which we received was the class should be in English. Okay, so obviously today's session is going to be a mix of English and Hindi. Okay, so we will make sure that those students who cannot understand some specific terms can also understand it. Fair enough? So let's start with today's session. Today's session is basically about law of torts. In the last class, we were discussing about rights, duties, discussing about liberty, liability, etc., etc. So in today's class, what we're going to do is we're going to explore a branch of law which is the easiest when it comes to understanding what we discussed in the last class about rights, duties, liberty, etc. The branch of law which we're going to study here is exactly the branch of law which generally is being taught to a student who goes to the law school first. This is one of those branches of law which is taught to you for the first, as in they won't directly teach you constitutional law. They'll be teaching you law of torts. ये पहला लॉ का सब्जेक्ट होगा जो कि आपको फर्स्ट ईयर में ही पढ़ाया जाएगा. There's a basic reason behind it, and the reason is this is basically unwritten law. Okay, unlike any other law, this is not codified. That means you won't find an Indian Torts Act. You get it? Like we have Indian Contract Act for contracts. We have an Indian Penal Code for criminal law. Law of torts is something which is not codified. You won't find any specific enactment for the same. But on the other hand, the legal concept called as torts is defined in a particular act which is called as the Limitation Act. That is exactly where it has been defined. But otherwise, it is not even defined. So this is the beauty about law of torts, that this is something which is again called as a judge-made law. So when I say judge-made law, what I mean to say is this is basically a kind of a legal system which judges of this country have actually propounded. They are the ones who were very instrumental when it came to this particular branch of law. So this is something which is connected to a particular thing called a civility in the society. Okay, so let's start exploring it. It's a very interesting branch of law, believe me, because here you need not frame something up. You need not ratta-fai marne ki zarurat nahi hai. Common sense hai. It's completely common sense. So whatever we are going to discuss today, if you listen to it, you'll feel it. This is nothing but pure common sense, and that was one of the reasons why it was not codified. One of the reasons why specifically it was taught, or it was taught in the law school for the first, is because it is very easy for a student who has just taken up law to understand it. Okay, so let's explore it today. Now the first thing which we will discuss today is about the word called as tort. Okay, now tort is a word which is derived out of a Latin term called as tortum, which basically means a conduct which is twisted, wrong, not straight, or unlawful. So let's get it straight. Torts means something which is twisted, wrong, not straight, unlawful. Now, if I have to explain this very clearly, I have to, because a wire can also be twisted, so is that tort? No. So when we are referring to a twisted conduct or a straight or something which is not straight, what are we referring to? We are referring to the society as a whole. So things which do not go as per the acceptability of the society, that is exactly what we are referring to here. You getting it? So in a particular society where Holi, a festival, most of you might be celebrating it, is considered to be acceptable, that is something which won't be a tort. For example, in India, if you are celebrating Holi, you are applying color over, people's face. People are going on the vehicle, and you can throw a bucket full of water on them. That is not something which can be considered as a tort. Where in India, but that is exactly the acceptability of the people. That is not a conduct which is twisted, wrongful, straight, etc., etc. But on the other hand, imagine doing the same in England. Say you got placed, you are in England. आप इंग्लैंड में चले गए and आपका placement हो गया. All of a sudden you receive a phone call from your mother wishing you happy Holi, and all of a sudden you realize, अरे आज तो होली है. What do? कलर उठाया और कूद गए सीधे स्ट्रीट्स पे. वहां पे एक गोरा आदमी मिला. यू मीट अ फॉरेनर, एकदम उसके ऊपर कलर लगा दिया आपने, and you're like happy Holi. You getting it? So in case if you do that, do you think that person is going to leave you? He's going to sue you, because there what you have done is something which is a twisted, wrong, not a straight conduct as per the given society. You getting it? So tort law is a lot connected to the particular society where you live in, and when we talk about conduct, a particular acceptable code of conduct, that depends a lot about what is the acceptability of that particular society relating to that conduct. You getting it? That is exactly what is called as tort. So we live in a country where tort law is not very famous. It is not something which you would, if you walk into the court, maximum number of cases will be of family law cases, property disputes, criminal law, etc., etc. But there will be very handful cases of torts, and tort cases will be only, there will be only, you can find more number of case laws only in those cities which is very developed, because tort law wants a kind of a society where people are very aware about their rights, which I am very sure you will also agree that our Indian society is not. You getting it? For example, as I said, even to touch a person, as per law of torts, even to touch a person, you require his permission, because his body is a body of rights. He has different kinds of rights. You might have seen the kind of arrests that happen in and around you. And if you might have even seen Hollywood movies, you would have seen that even before a police wala goes ahead and tries to, tries to arrest a person, the first thing he does is he'll go to the person and tell him, you have a right to remain silent, and anything that you're going to do is going to go against you in the court of law. And what does the other person do? He will, he will surrender. He will say, okay, you can arrest me. So this is the kind of, or this is basically the kind of, what you call the awareness of rights which people have in Western countries. But in our country, that is not that big a hit. But yet, it is taught to you because this is the basic underlying principle of law. This is one of those legal systems which basically evolved further and became the legal system of around the world. And that is one of those reasons behind it. Okay, I'm hearing a lot of no sound from all of you. Is it the same case with everyone? Can I get a yes from all those who can hear me? Okay. Okay, great. What about the rest? I think few people are having a problem. So okay, they'll contact. We'll go ahead with the class because we have a a strict timing. Okay. Okay, the rest are also getting to hear about it. Okay, chalo, let's move ahead. So, what is law of torts? Law of torts is a kind of a legal system basically, where specifically, the civility aspect or as the civil right aspect is something which is considered. Now I have, now I'm talking about something called as civility. Getting it? Civility. Now, what does civility mean? That is something which we have to dwell further. That is something which we are going to discuss here. Now, what is law of tort? If you can see the definition there on your screen, you can also see that it says a tort is a civil wrong for which you get unliquidated damages. A tort is a civil wrong for which you get unliquidated damages. So in this particular definition, there are a few words which we have to consider. The first word which we're going to consider here is called as civil wrong. Now read it. What does that say? Committing an injury, violating someone's legal right. Now guys, there are many kinds of rights which we have. Okay, there are certain things which are called as right in rem, while on the other hand, there are certain things which are called as right in person. Okay.
So the first, if we look at the definition of tort, it says that a tort is a civil wrong for which you get unliquidated damages. There is a difference between the term damage and damages. Damage means the actual harm which a person suffers, and damages is the amount of compensation which is given to a party. There is a difference between a civil wrong and a criminal wrong. A civil wrong basically means that is something which is hampering the right of a particular person, while a criminal wrong means something which is hampering the right of society at a large. Now coming back to damages, basically there are two types of damages. The first is liquidated damages and the second is unliquidated damages. Unliquidated damages means when you are doing something, when you are entering into someone's land, basically you are committing the offense of trespass. So in that case, the other person on whose land you have entered will not decide the amount of compensation which you are supposed to give to that person. So basically whatever injury a person is suffering is decided by the court. The court determines the amount of compensation that has to be given to that person. In case of liquidated damages, it's basically between the parties. Like if A and B, there are two parties and they have entered into a contract, and the contract is for the supply of certain goods and services. And for example, because of certain reasons, the other person cannot supply the goods. So in that case, there is breach of contract. Like if A and B has entered into a contract and the contract is related to the transfer of fruits from Lucknow to Mumbai, or for example, from Hyderabad to Mumbai. But because of the recent rainfall in Hyderabad and the flood situation in Hyderabad, it's not possible for the person to transfer the food from Hyderabad to Mumbai. So there is a breach of contract. So in that case, if certain amount has to be given because the other person has violated the right, so in that case, the amount which is already decided by the party, in case of violation of the contract or breach of contract, I'll pay you this much amount. That is basically liquidated damages. In unliquidated damages, the damages amount or the compensation amount depends upon what actual injury a person is suffering. Now coming back to the If you look at the slide, it's clearly defining what is a civil wrong, what is unliquidated damages, and what is liquidated damages. Civil wrong says that committing an injury, that is violating someone's legal rights. There are two types of rights. One is basically you are violating the legal right of the other person, and the second is basically because of your act no right has been violated. So in that case, when there is no right being violated, you cannot ask for compensation. You can claim for the compensation only when your right is being violated. Then there is a question, what is an injunction? Injunction is basically when you file a suit in the court. When you file a suit in the court, court will either pass an order or court will pass an injunction order or interim relief. That basically means that the defendant is stopped from committing certain acts. So basically court puts a restriction on the person that unless and until this matter is decided by the court, you are not supposed to use your land, you are not supposed to violate the right of the other person, you are not supposed to enter into property of some other person. So that is basically an injunction. Then there is a difference between civil and criminal wrong. So basically, if you look at the slide, it clearly says that what is the difference between civil wrong and a criminal wrong, or for that matter, what's the difference between a tort and a crime? A tort is basically private, isn't a private wrong. It's in private nature, whereas a crime is a public wrong. There are various wrongs which can be listed in both the tort and in criminal wrong. So basically there are various wrongs which find their places both under the criminal law and law of tort. Example are assault, defamation, negligence, nuisance, conspiracy. Wait, I have changed the slide, but I am getting the query that there is no slide change. I have already changed the slide. Can you all see the new slides which is talking about the difference between civil versus criminal wrong? Yeah, fine. So basically I was talking about there are various wrongs which find their places both under criminal law and law of tort. For example, if you are committing an assault or if you are committing defamation, for that matter negligence, nuisance, conspiracy, both will find places under tort and under criminal wrong. For instance, if a person digs a ditch on public road and which is causing inconvenience to the public, in that case it would be a crime. But if a person or a passerby falls into that ditch and thereby gets injured, then the act of a person also becomes a private nuisance. So it basically depends upon the case and it depends upon the magnitude of the injury which a person is suffering. Like if it is causing injury to the public at large, so in that case it would come under criminal law, and if it is causing nuisance or it is causing injury to a private person, it will come under tort. So basically if you refer to the civil versus criminal wrong, the list of civil wrong is less serious. Why? Because it is against a particular individual. It is against a private person. Criminal wrong is more serious. Why? Because it deals with public at large. It hampers the right of society at large. Then civil wrongs deal with the private rights and duties of individuals. That means you are not supposed to enter into someone's premises. For example, if you want to enter, like people do visit Mumbai and they are very interested in going to Shah Rukh's place or Amitabh Bachchan's place. So in that case, you cannot enter into the premises of Shah Rukh or Amitabh Bachchan without their permission. So that is basically the right of Amitabh Bachchan or Shah Rukh, that you can't enter into his premises and it's your duty not to trespass into his property. Then criminal wrong deals with the offences against society as a whole, like ditching or dig at road or public road. That is basically you are creating trouble for society at large. In case of civil wrong, the petition or the suits are brought by individuals. For example, if my right is being violated, I can only file the suit. No one else will come on my behalf that yes, I'll file a suit on your behalf. But in criminal wrong, there's always one party which is state. Recently, for example, you must have watched the movie Rustam, and it was based on the famous case Nanavati versus state of Maharashtra. So basically, here you can see that the defendant is state of Maharashtra. So in criminal wrong, always the prosecution is done by the state. Then in case of civil wrong, there is a concept of damages. That means there is a concept of compensation. But in criminal wrong, there is always the concept of punishment. But this is not the case now. Now, apart from punishment, under criminal wrong also compensation is given to a party. For example, you must have heard about various cases in which the person after, the tenure is over, he or she is still serving in jail. You must have heard somewhere in Husaina Ara Khatun case. In that case, the lady, she was not aware of her rights. She was not aware of the fact that she can come out of the jail, and she was there in jail. So in that case, the court evolved the concept of compensatory jurisprudence. That means now under criminal wrong also, compensation can be given to a party. Coming to the next slide, how a tort is committed. But before that, I would also like to tell you what's the difference. Now we have studied the difference between civil versus criminal wrong. There is also a difference between civil versus, between law of torts and law of contract. Law of tort is also a civil wrong, and law of contract is also a civil wrong. However, every civil wrong is not a tort. Like tort is a civil wrong, but every civil wrong is not a tort. It can be listed under contract also. The major difference between the law of torts and law of contract is under law of torts there is a concept of unliquidated damages, while under law of contract there is a concept of liquidated damages. And in exam, like if you refer to the past year CLAT paper or past year NLUD paper, you'll find there's always a question on unliquidated damages or liquidated damages. They might ask you what's the difference between so basically they'll ask you in torts whether there is a liquidated damages or unliquidated damages. So in torts there is unliquidated damages, while in contract there is liquidated damages. In contract, the parties are known to each other. In law of torts, the parties are not known to each other. So now coming to the next slide, this talks about how is a tort committed. So basically, there are 4 stages of committing a tort. The first one is act or omission. That means on the part of defendant. That means act means something which a defendant was not supposed to do, but he did, like I am not supposed to enter into someone's premises without the permission of that person. So in that case it is basically something which I am not supposed to do, but I am doing it. Then there is omission. That means I am supposed to do something, but I have not done that. For example, in case of negligence, I am supposed
I'll take it further from here. In case of negligence, as she said, basically a person has a duty of care towards other people, and if he does not do that kind of a duty and goes ahead and goes ahead and infringes the right of the other person, he may not do it intentionally, so there is no intention here, but yet he may end up infringing the right of that other party. So he may say, okay, this is kind of a mistake on my part, but then we cannot forgive him, because then everyone, mistake, as we say, mistake is is a small sister of negligence. You're getting it? So that is how it goes. So now, how a tort is committed in a particular given society, there are certain code of conduct which we have to follow, and if we do not follow it, there can be a situation where you will go ahead and infringe the right of a person. For example, if It is upon me to behave in a particular manner on the road, where if I'm driving the vehicle, I have to be very clear that, I'll drive it properly. I'll see to it that, when I'm on a particular, say, alley, I will, blow horn. I will inform the people who are besides me that, I'm going to be there, I'm there, so that they get a kind of a caution that, okay, someone is driving, and then they are also cautioned, and they all. So you might have seen, this is something which you also follow day in, day out. When you'll be driving on the road, say when you're crossing the road, following the traffic light, etc., etc. There are many kinds of duties which we have, and the moment we do not follow that kind of a duty, that is exactly where, this thing happens, a tort happens. Now, as Suhasini said, when you differentiate it with criminal law, in criminal law, this offense is against the entire society. You getting it? So that becomes a crime, and that is more serious. And that is why in criminal, when you commit a crime, it is the government which comes and prosecutes you, not individual. But on the other hand, if something happens to me, say my own personal right gets infringed, I can go to the court and file a case against the person who has committed a wrong. You getting it? So as it says, act and omission on part of a defendant. So both of them are there. Either you act or you do not act. Both of them. Because, at times when you are not acting also, you can end up, committing a crime. For example, I keep piling, say garbage inside my house. I do not throw it away because I am too lazy. So I'm like, pade rehndo yaar, kachara pade rehndo, kaun jayega feekne ke liye? Now it starts depleting. You're getting it? And one fine day, it starts smelling so bad that all my neighbors, they are getting bothered. They're getting, now anyone can file a case against me. They would take, this kind of a foul smell, even though he's using his own property, but that smell is coming to our house and that is causing us disturbance. So see, I did not act. You're getting it? I did an omission of something, but yet, I infringed the right of another party. So even those things are included here. You're getting it? So the word used here, I'll go back to what I was, referring to, is civil. So most of you might have heard, your parents might have also, when you were very young and when you were behaving in a very different manner, your parents might have at times told you, behave civil. You're getting it? Civil, Hindi में बोलेंगे तो सभ्य लोगों की तरह act करो. क्या कर रहे हो तुम? जानवरों जैसे behave कर रहे हो. So that is exactly. So wherever tort law, you go to any city and you see that the standard of life of people is quite high there, you can be assured of one thing, that the people there are aware about their rights, they know about their civil rights, and that is why they take care of all those things. And on the other hand, if you go to a society and you can see that, कुछ भी किसी भी तरीके से चल रहा है, you can be rest assured, and people don't know about their rights. And that is why the kind of life which they live in is called as uncivilized. You might have heard, many of you might have heard, किसी को देख के हम लोग बोलते हैं, but uncivilized behavior है यार. But on the other hand, if you behave in a very good pattern, so they say, "Yaar, bada civilized banda hai you." You're getting it? So the entire crux of tort law is how civil are you in your behavior? You're getting it? Now, if you see the antonym of civil, it goes like animal. You're getting it? Because we humans feel that animals are not civilized, so we say, "Okay, animal type behavior." So this particular, the entire crux of tort law is you have to behave in a very civil manner. You have to behave in such a manner that people look at you and they're like, "Yeah, this person behaves well." Now, this if you look at the slide, it says this A or O must cause injury to the plaintiff. Now, if I don't do anything and if I do something, if it does not causes injury to anyone, no one can file a case against me. You get it? So there has to be a kind of an act or omission on my part which goes ahead and injures other party. Only then a case can be filed against me. Now, as it says, consequent to the injuria, plaintiff may or may not suffer a damage. He may or may not suffer a damage, but if there's a legal damage which he has suffered, which cannot be seen. So there are two kinds of damages which we have. A damage which you can show. हाथ में लग गई, you can go and show. कि देखो मुझे लग गई. That is a damage which we are talking about here. There's another kind of a damage which you will not be able to see, but the person has suffered a damage. For example, a damage to my reputation. If I go and say this person has defamed me, So can I show it to the judge? कि okay, defamation. The judge will say, कहाँ लगी तुमको दिखाओ defamation कहाँ पे लगी? So will I be able to show defamation? I may be able to show defamation when I go ahead and say कि my reputation, this is my goodwill, and this is where it hurt me. I can use such kind of dialogues. I can I can say like that. But tell me one thing, that is where you say damnum sine injuria and injuria sine damnum, that there are certain injuries which you may not be able to show, that will be very intangible. But yes, there is a damage, and that is called as a legal damage. Agreeing it? There is something called as mental shock, or mental agony, which is taken as a big injury in law of torts. You cannot explain it. You can just go, you cannot show it. You can just go and explain it. We Indians don't understand mental agony because हमारे साथ बहुत कम ही होता है, because we are mentally very strong people. I'll tell you a classic case that when 9/11 happened in United States of America, those people, the Western country guys, they are very sensitive from their heart. So when 9/11 happened in United States of America, you guys won't believe it, that maximum number of Americans had a mental shock. And the mental shock resulted in such kind of an economic disbalance in the United States of America that maximum number of people in the United States of America said, we are not going airlines. हम लोग airlines में जा नहीं रहे हैं. When they were going down, skyscrapers, they used to get this kind of a mental agony कि अरे बाप रे buildings गिर जाएंगी. And psychologists, they were minting money out of it. You won't believe it. So how were they minting money out of it? Because mental agony. People were being called. They were being counseled. But now think about India, just compare it with the situation in India. In our India also, 26/11 happened. No, Mumbai, which you might have seen. The day 26/11, the Mumbai, bomb blast happened in the local, in the Mumbai local. The next day, more and more people got into the local train. That is a kind of a spirit which we have because we don't understand something called as mental agony. But law of torts does recognizes it. Law of torts recognizes it in such a module that if a person was enjoying his right and another person committed a kind of an injury to that right, then that person can say that I have suffered such kind of a mental agony that I cannot enjoy that right of mine because that has affected me. For example, if I'm drinking a Coca-Cola and some alien object comes out of that Coca-Cola, you getting it? Now, that could be a dead worm or something. Now, damages can be given to me for any kind of a physical injury which I suffered. Say, I had a food poisoning, etc., etc. But on the other hand, what about the kind of an injury, a mental agony which I have got, that now whenever I feel like having Coca-Cola, the same memories of that particular alien object starts coming into my mind. You getting it? So that is mental agony for you. How many of you have mental agony? I don't know, but yeah, so we do have. For example, females. If you're standing on the road and a very accident happens because of the negligence of a person, and you can see all blood spilled over here. Some of us are very mentally strong. We look at it. We want to see the dead bodies. You might have seen many WhatsApp messages nowadays are coming like that. We keep forwarding to each other. कि अरे ये देखो ये accident यहाँ पे हुआ, ये लाश पड़ी हुई है. Some people can stand it, some people cannot stand it, and that is exactly what we are talking about. That's a kind of a mental agony that we have. You getting it? So that is also calculated here. That is what is called as damnum sine injuria, injuria sine damnum. Damage without legal injury without damages. I hope I'm clear to it. So we'll move forward and we'll explore the session further. Now, how a tort is committed, we've just discussed this, the two rules. That is injuria sine damnum sine injuria. So I'm not just going ahead and discussing it further. Now, the various types of torts. Now, these are the types of torts which are most frequently covered by CLAT. CLAT has a habit of asking you questions primarily from this. Now, if you ask me, the number of questions each year in common law admission test or say ALIT come from law of contracts, but these are a few topics which are vastly covered, and I would say maximum number of questions come from here. The nuisance, negligence, defamation, malicious prosecution, trespass. But we'll be discussing these things only in the next class, not in this class, because what are we going to discuss today is called as the general defenses of tort. If you remember my last class, in my last class we were discussing about rights, duties, and liability. Then I referred something as liberty, which were basically defenses which usually people use when they want to, defend their case. For example, if any one of you would accuse me that, he committed this kind of a tort on me. So, I'll be heard. So when I'll be called, I'll be using these defenses. Now not just we, that's a pattern of teaching law, that whatever branch of law you'll be taught, you'll be first taught these general defenses, or as the liberty which you have, or as the defenses which you can use before the court of law. Why? It's very simple. Before learning how an infringement of a particular right happens, it is very important for us also to know that in which all consequences such kind of an infringement may also go unpunished. Only then you can understand those things. Because if we start teaching you, nuisance, negligence, defamation, malicious prosecution, you will start asking us, sir, what if aisa ho gaya to? What if aisa ho gaya to? You're getting it? So that is the reason why, this thing is taught first. So now defenses in tort law, as we said, these are one by one each defenses. VOLENTI non-fit injuria, plaintiff is the wrongdoer, inevitable accident, act of God, act of private defense, mistake, necessity, act under statutory authority. Okay, so we are going to discuss each one of them one by one. Okay, so the first defense which we are going to discuss here is called as VOLENTI non-fit injuria. This is also called as defense of consent. What does VOLENTI non-fit injuria means? VOLENTI non-fit injuria means voluntarily exposing oneself to injury or risk. Okay, I repeat, voluntarily exposing oneself to injury or risk of getting injured is called as VOLENTI non-fit injuria, which specifically means that if a person knew that there is risk, if a person knew about the risk associated with whatever he is going to do, and then he suffers that kind of an injury, the law of tort says, hello, you knew about the particular risk which you had, you knew about the injury which you may suffer, then why did you expose yourself to that injury? You getting it? Law of tort says that you knew about the risk involved, you had the knowledge of the risk, then why did you go ahead and, because we see that you had already consented to the risk. That is why it is called as defense of consent also. You getting it? There are some things which are very, very important in VOLENTI non-fit injuria. The first thing is that the person had the knowledge about the injury which he is going to suffer. Okay, now I'll start giving you examples. I presume the maximum number of you go to malls. Okay, so when you go to park your vehicle, if you're in a four-wheeler, the moment you get inside, there is this automatic parking machine, the sheet machine which is kept there. So we go there, very stylish tarike se, and we press the button, the parking sheet comes out. Bada maza aata hai, it looks very Western. Have you ever taken pains to read that particular sheet? Because on that sheet there is a small message written down, that parking at owner's risk. Right? What is written there? Parking at owner's risk. That means, dude, we are giving you space to park, but the risk belongs to you. That means, whatever you are paying, 20 rupees per hour, 50 rupees per hour, they are giving you just that particular space there at 50 rupees per hour. That's the rent of the place. Anything if happens to your vehicle, they are not to be blamed. Because what did they do? The risk associated, they have already transferred to you through that check. You did not read it, that is your problem. Great. What is written there? Parking at owner's risk. Who's the owner of the vehicle? You are there. So if you are parking it here, we are not taking the risk. The risk is upon you. Great. We are just giving you space, that bit of the space where you can cover. So in case if someone is, parking his vehicle and he bumps into your vehicle, someone commits a theft of your vehicle, runs away with your vehicle, they cannot be accused for the same. That is exactly what you call as VOLENTI non-fit injuria. Okay? There are many examples of VOLENTI non-fit injuria. One of the classic examples is, the IPL match is on. You are very excited because Chris Gayle is batting. So you go take the ticket, जाके एकदम audiences वहाँ बैठ गए हैं and you're like great, Chris Gayle अभी छक्का मारेगा, and Chris Gayle doesn't disappoint. Dem मारा एक छक्का, straight away comes and lands on your nose. तुम्हारा इतना पूरा side fracture हो गया. Can you go and sue Chris Gayle? Can you go and sue the stadium authorities? कि बॉल आके मुझे कैसे पड़ी? Just read the ticket which is usually given to you. वहाँ पे भी यही चीज लिखा रहता है that the stadium authorities or the players are absolved of any kind of a liability or the risk associated with the sport. The risk associated with the sport. So a ball coming and hitting you is something which is a risk which is associated with the sport. So you might, all of you might have also seen WWE. So in WWE, those people who are seated on the aisle, that is the most expensive seat. And you won't believe it, guys, that is the most riskiest seat also, because when you go to witness WWE, the ticket also reads the same. Any risk associated with the sport, we do not take liability. Why? Because if two wrestlers are fighting and a wrestler throws another wrestler into the crowd, and that wrestler who might be around, 500 pounds comes and lands straight on you, breaking your spinal cord, can you file a case against the WWE? You may, but you will not succeed because, VNFI, VOLENTI, non-fit injuria. It means the defense of consent. You have already given consent. You have already consented कि हाँ ठीक है, risk है, देख लेंगे. You getting it? So that देख लेंगे is something which is happening with you. As I said, as it is written there, I know there is a risk and I agree to suffer consequent harm. I indeed suffer the exact same harm to which I consented. I cannot hold the person who inflicted such harm responsible. It's very simple. If I have agreed to it, okay. But believe me, in case there's a silver lining here, the risk was not told to you. Someone wanted to surprise you, and he said कि हाँ अंदर जाके देख लेना बहुत भयंकर है, and then you get hurt by something. So in that case you can say okay, you did not tell me what the risk was. You were just holding it over and you were saying कि ये surprise है, अंदर जाके देख लेना, blah blah blah. No. You have to be told about the risk. In case if you have been told about the risk and you consented to it voluntarily, I'm so sorry, you cannot have a cause of action against a person. Now there are some tricky areas as it is given here. Consent must be freely given. It should not be forced. It should not be defaulted consent and will not work. For example, if someone points out a gun on your head and says, give your consent, and you have given your consent, you have to just prove it that your consent was not a free consent. In that, even VNFI will not apply. Okay? Now, no agreement to suffer on account of negligence of defendant is treated as, VNFI. The most classic case in this, entire thing is of a doctor's negligence, which is something which even CLAT will ask you a lot, where they say that when you go to a doctor, the doctor makes you sign an agreement. The agreement says that all the risks associated with the operation, you agree to it, and you will not file a case against the doctor. Fair enough. That is something which is very legal. So if you are undergoing an operation, they make you sign it. But what is the clause used there? That any risk which is associated with the operation. You're agreeing to all those risks. So fair enough, you agree to it. So in case if you're diabetic and if there is an operation which is being conducted upon you and all of a sudden your kidney starts malfunctioning, the doctor has a consent from your side that he can cut off one of your kidneys. You getting it? Because that was the need of the hour. But on the other hand, if you read it carefully, what is written here, no agreement to suffer on account of a negligence of defendant is counted here. It means if your doctor starts operating you, he's literally आपका पूरा पेट खोल के रखा हुआ है उसमें, and all of a sudden, he gets a phone call. You getting it? And in attending the phone call, what he does is he leaves his pair of scissors and his gloves inside your stomach. You getting it? And he stitches it. After some time, and you are discharged. After some time, you start feeling a kind of a sensation in your stomach. You go for a second opinion to some doctor, and the doctor says, "ये क्या है? ये आप खाते हैं क्या?" There is a pair of gloves inside your stomach. There's a pair of scissors. So, what is this? This is the negligence of the doctor. Now, this is not something which is taken into consideration. So, if you read it carefully, what is it written there? That the negligence of the defendant is not applicable here. If there was a duty of care on part of him and he did not do that duty, and he was negligent, that is not what we are talking about here. We are talking about a risk which he has said, which is a genuine risk, and only he can be saved under this particular defense only in that genuine risk. Okay? So that is VOLENTI non-fit injuria for you. Okay? That next is it is not applicable to rescue cases. So in case, as it is written down there, you go into a burning building to save someone and suffer burn injuries, person causing fire cannot argue that you knew there was a risk involved and willingly took the risk. Okay? So that is something as a silver lining which we can see here, that if you are going into a burning building to save someone and suffer burn injuries, person causing fire cannot argue that there was a risk involved and you knew it. The very thing that why you were doing it is just because he committed a breach of his duty and you had to go inside because of this person. So he cannot say VNFI tha. You're getting it? The rescue cases is what you call as an exception to this general exception, which is called as VOLENTI non-fit injuria. You're getting it? So I think we have a question related to this. You can just take a look at it, and Suhasini is going to answer it. So just go through this question, apply what you call as VNFI. There's a principle, there's a fact situation, and you also have some options. The question goes something like this. As for the principle of VOLENTI non-fit injuria, a person who is aware of a risk and assumes the risk voluntarily cannot claim damages if he suffers on account of the risk. Very simple, what we had just discussed. And then it says, Nandu, a minor aged 13 years, does odd jobs to supplement the family income. Mr. Gupta offers him ₹500 to clear his plot of land adjoining a sprawling orchard of thick vegetation. When Nandu asks Mr. Gupta about the possibility of a poisonous snake in the plot, he tells Nandu that although he had never come across even a scorpion, however, he should be careful while chopping at the shrub roots since the plot was adjacent to the orchard. Nandu, in an attempt to complete the task before the dusk, starts cleaning the shrubs and bushes, and indiscriminately, and while he is clearing, one of the last few bushes is bitten on his palm by a non-poisonous rat snake and develops sepsis, that is an infection. Nandu sues Mr. Gupta for not providing him with gloves. So now, what could be your answer? So you can just type in your answer and send it to us. Yes. A. Shailendu says it's A. Vedant says it's A. Maximum number of people says it's A because of the principle of VOLENTI non-fit injuria. Oh, that means VNFI is very clear to maximum number of you because yes, A is exactly the correct answer here. Yeah, because see, we had a B coming from someone, because they think that Nandu can claim damages since it was the duty of Mr. Gupta to provide him with the protective gear. Now, this is exactly where we go emotional, I think, You went emotional, you thought, ki nahi, dena chahiye tha, etc., etc. But if you see, he had already cautioned him about the same. He had already told him that this may happen. You getting it? So, the risk was already told to him. You getting it? So, the answer here is A, like maximum number of you feel. Moving on further, now this is the next, general defense. The next general defense is called as plaintiff is the wrongdoer. Okay, plaintiff is the wrongdoer. Now here, the term plaintiff refers to a person who goes to the, in civil cases, the person who goes and files a case is called as plaintiff. Agreed? Plaintiff. Why is he called as a plaintiff? Because the civil complaint which you file in the court, the complaint is called as plaint, and the person who files the case is called as plaintiff. The one who will defend himself shall be called as defendant. Okay. So now, plaintiff is the wrongdoer. What is this defense all about? Plaintiff is a wrongdoer. The defense means that the one who is going to the court and filing a case against a defendant, he himself is a wrongdoer. That means he is not going to the court with clean hands. Getting it? He's not going to the court with the clean hands because he himself has committed some kind of an error. Cool. So when does that happen? Just take a look at it. Now, no court will help a person whose case is based on an illegal act. I suffer an injury. I say injury was inflicted by the defendant. It turned out that I was myself responsible for the injury and the defendant had nothing to do with it. Simple. I'll give you an example. Our birthdays, when we are about to celebrate our birthday, our friends do surprises at 12 o'clock. They all of a sudden come up with a cake and all. So now, for security purposes, what we have done is, we have a dog at our place, a Rottweiler. So, हमने रात को 12 बजे उसको खुला छोड़ दिया, ठीक है? We made it clear that it's because of our security. Now all of a sudden these guys pop up. They are like, they want to surprise you. The moment they jump into your house, into your property, and when they are very close to your door, your dog surprises them. Your Rottweiler goes and starts biting each one of them. So now in this case, you already had something there which is called as a particular board which says beware of dog. Now these guys are committing a wrongful act because in case if they wanted to surprise you or if they wanted to do something, this is not the way. Now substitute your friends with a thief who comes into your house to commit a theft. Now the moment he comes in, your dog bites him. He bites him very badly. So can he file a case against you? Can he file a case and say कि यार ये कौन से breed का कुत्ता पाल लिया, Rottweiler, Pomerian पालना चाहिए था, भौंक देता तो मुझे पता चल जाता तो मैं अंदर नहीं आता? Can he say like that? No, because he himself is committing a wrongful activity over there. A person who's coming from the wrong side and rams his vehicle into your own vehicle, into your vehicle, which is on the right side, the moment he does that, he has no cause of action. You getting it? But in this, you should be someone who should be rightful. In case you were also negligent, that is something called as contributory negligence, which we'll do it in the next class. But plaintiff as a wrongdoer means the person who's a plaintiff, who's going ahead and filing a case against you, he should also have committed some kind of a wrong. You getting it? So he has no cause of action. But there are certain tricky areas even here. It says that if the cause of injury is the defendant and not plaintiff, this defense will not work. That means if the cause of injury was the defendant and not the plaintiff, this usually happens when there's a case of a contributory negligence. Like, for example, I'm on the right side of the road. I'm on the right side of the road, but all of a sudden it's night. And what do? I switch off my headlights. I switch off my headlights, and I just want to I just want to feel some bit of adventurous. So what do? I switch off the light and I'm like, chalo maza aayega, dekhte hain kya hoga. Because it's a one-way road and no one is going to come from that end, and I start driving. But I am surprised by a gentleman who's coming from the wrong side. So in this case, see, even I contributed to the injury. No doubt about it, this guy was coming from that end, which was a wrong end. But then, I also contributed to it. So that will be something which is an exception to this thing. Now, defendant is not allowed to do anything just because plaintiff is a wrongdoer. That is not applicable to the case of nuisance, where you are not allowed to do something because the plaintiff is actually the wrongdoer. Plaintiff has committed a wrong, and you cannot go ahead and do just anything. For example, you can have a dog as a pet, for your protection, because that is something which is legal in nature. But that does not mean that for your protection you start having a lion or a tiger as a pet. You may be laughing at this idea, but believe me, this is something which happened in our country. There is a gentleman in Uttar Pradesh. His name is Raja Bhaiya. So the government of India conducted a raid at his home because they got to know that what is Raja Bhaiya up to. Raja Bhaiya had a palatial house with big walls all around. And just besides the wall, that means if someone wants to do a sting operation on his house, they're jumping the wall. Just besides the wall, he had big trenches, gadde gaad ke rakhe the unne, getting it? And gadde gaad ke, uske andar, he used to, breed piranhas. You understand piranha? It's a fish which can even munch on your bones. There were piranhas and there were crocodiles which this guy was actually breeding. So when the government of India conducted a raid, they could find that there were so many piranhas and there were so many crocodiles, and they were like, what are you doing? To which he said, I am defending myself. You getting it? The government of India, confiscated every animal there, and they said you can have guards, you can have dogs, but that does not mean that you go to that extent. So which Raja Bhaiya had the defense like, anyone who's going to jump from there, he's a wrongdoer and he should suffer. But that is not the logic of the law. The law says no, you cannot just go ahead and do whatever you feel like. Now there is something which I want to discuss here. It's about electrocution of fences, the electrification of fences. That is not legal in our country. The only people who can do it, that is electrify the entire campus, are government agencies, specifically the army and anywhere where there is a Z kind of a security which is given. Getting it? So no individual can do it. The government can do it. So if you face a question anytime where it's about electrification of campuses, there is only one answer, and the answer is no. You getting it? That is something which is called as extreme measure. And if the plaintiff, even if he's a thief and if he's trying to get into your house and he gets electrified, you shall be held liable. Right? So let's solve a question. Okay, we don't have a question for it. I guess it will be something which we will combine and ask you. Now, the next is inevitable accident. This is also a defense. Now, the word says inevitable accident. There are two words. One, accident. You getting it? Accident. What do you understand by accident? Accident is something which just happens. You getting it? So the defense is not just accident. The defense is inevitable accident. It means an accident which could not have been avoided. So if you are driving on a road at a speed of say 120 km per hour and the prescribed speed is 80 km or 40 km per hour and you meet with an accident, can you call it as an inevitable accident? No. For the simple reason that this is an accident which you could have avoided. The speed limit is something which is say 80 or 40 km per hour, but you were driving at a speed of 120 km per hour. You're getting it? So that is not something which is advisable. That is not something which you can. You're getting it? That is something which can be called as an accident which you could have avoided. Here we are talking about an inevitable accident where things were not in your control. And as it goes, an unforeseen, unexpected and an unavoidable injury that happened in spite of reasonable care taken by the defendant. You're getting it? Now these words are very, very important. Go through it. Unforeseen, unexpected, unavoidable and despite reasonable care. All these things have to be there. In case if these things are not there, I'm so sorry, you cannot take up this defense. You're getting it? Inevitable accident. So I can give you an example. It's very simple. You buy a new car, a Honda Brio. Now, you're driving it on the road and all of a sudden the brakes don't work. Why? Because there is a manufacturing defect. You go and bump your vehicle into someone. What kind of accident is this? Unforeseen, you could not foresee because your car is brand new. Unexpected, you never expected it. It's just brand new. You're getting it? So, you could have just, you could have just drove it much better. Unavoidable, because if the brakes just go off, how can you stop the car? Despite reasonable care, come on. I am taking the reasonable care because that's a brand new car. You getting it? Now, what could be an exception to this? The case which we have just discussed, Honda Brio case, that is something which you can call as inevitable accident. But on the other hand, what is not an inevitable accident? You buy a Honda Brio, the first service date passes on, you are like, "Arey, aaram se jayenge." You are an alsi fellow, you don't go. The second service date passes on and you are like, "Arey, nayi gaadi hai, abhi to chalegi." But because you are not taking care, now look at that particular word there, despite reasonable care. You're getting it? Here, are you taking reasonable care? You are not taking it. Is it unavoidable? Now the accident which you're going to enter into is avoidable. You did not avoid it. Unexpected, you have to expect it. Because servicing the vehicle is very, very important. Unforeseen, you may say, "Arey, maine nahi foresee kiya tha," but law says you should have foreseen. First service, second service, you avoided it. Now what is happening? You drive on, you go ahead, you bump your vehicle into something. No, you cannot call it as an inevitable accident because this is a kind of an accident which you could have avoided and you did not avoid it. Not just that you injured yourself, you also went ahead and injured many other people. Right? So that will not be called as inevitable accident. That will be called as an accident, which is an accident and it is intentional. For inevitable accident, these all things have to be there: unforeseen, unexpected, unavoidable, and despite reasonable care. You getting it? These all things make up and what you call as inevitable accident. So I hope this is clear. Inevitable accident, what does that mean? That it just happened. It was not in your control. So the first Honda Brio example which we discussed, that is something which you have to remember. Okay, so that is inevitable accident for you. Now here is a question for you. Go through it and give me answer quick. Yeah, it talks about a particular event, something which we have just discussed. There's a person called as Noor. He drives a 15-year-old lorry and gets it regularly serviced. Once while he was driving on the highway at a fairly high speed, the engine of the lorry stopped, and as a result of this, the truck behind the lorry rammed into it. The truck driver sustained a broken jaw because of this accident and sued Noor. Noor was found to be in fine state, and Noor had papers to prove that he had got the lorry service. Later found out that as per the road safety manual, a load-carrying vehicle, including a lorry, was not fit to be driven on highways after 10 years of purchase. So what do you guys think is the answer? Okay, I am getting lots of C here. There is just Kiran who thinks that it has to be A. Okay, Giri Raj also thinks that it has to be A, that Noor can use the defense of inevitable accident. Maximum number of people feel Noor had violated road safety norms and hence he should be held liable. Now guys, one thing which I want to tell you all is, please, when you are choosing an option, it has to be something which is closer to the principle, and I don't think C is an option which is closer to the principle, because that is something which talks a lot about what? The facts. It has nothing to do with the principle. Yes. So now people are saying A. Okay. Okay, now people are getting it right. Yes, the answer is A. Noor can use the defense of inevitable accident. Yeah. Ab dimag ki batti jali, right? Yes, very true. A. Why? Because see, if you see the principle quite carefully, it says should not be foreseen. Could he foresee it? Because he was someone who was regularly servicing it despite reasonable care. That is the part of the reasonable care which he was taking. Now, the road safety manual, whatever it was saying, that you should not be carrying more than 10 years of purchase. Do you see anything in the principle which says that it should be against the law or something? There is nothing which is written out there. So this is a lesson which you have to be very clear about yourself, that when you say when you solve the question, there can be times when you can think the answer is very blunt, the answer is something, but here principle is always the key. You remember in the first session, that is exactly what I said. So here the only thing which you have to see was, could it be foreseen? Did he take reasonable care? That's it. And if he did that, the answer has to be that. Again, you guys are again asking me why. I again repeat. The only thing that you need to see in the options is, could he foresee it? Did he take reasonable care? That's it. You need not check into all those nitty-gritties which are intentionally given there as trap to you. You have to stick to the principle. And sticking to the principle, you have to come out with the answer. You getting it? And that is why many of you might be right. Under criminal law, you might be right because you're going against the law. But here, you have to just follow the principle. And the principle, as per the principle, if you say he was following it, you getting it? Yeah, you are perfectly correct. That is exactly what I'm saying. But please listen to me. You know what I'm saying? You have to follow the principle quite carefully. Whatever the principle is saying, that is the answer. Now, reasonable care of the safety norms is not something which is seen as a reasonable care of the safety norm. Where is it written in the principle? It says reasonable part on the part of the defendant relating to any activity which he is doing. You getting it? That activity which he is doing, and was the accident connected to him not doing so and so? You getting it? The engine of the lorry stopped, but what is the reason behind it which is given over here? Right? So that is exactly the the answer to this question. Okay. So now moving on further, act of God. This particular defense is also called as vis major, as you can see there written down. Now, what is act of God? This is a kind of an injury which most people sustain because it was not the problem of the plaintiff. It was not the problem of the defendant, but this injury was caused because of a natural calamity. You getting it? But now there is a fine lining which I want to draw here and which I want to be very clear about is, an act of God defense can only be applicable, and you can use act of God as a defense only if, I again repeat, only if you could not avoid it. Even if after a natural calamity, even if it be a natural calamity, if you can premeditate and predict it that this may cause injury to any person, and you do not do anything to avoid it, you can be held liable. I'll give a very classic example related to it. The monsoons were on. Now, in your home, you have a huge tree, and before the monsoons, the entire colony walas come and tell you, sir, please trim the tree, because the monsoons are going to come. The monsoon can also bring thunder showers, so it's better for you that, you just trim the tree. And you are like, हाँ करवा देंगे बुलाया है बंदे को, वो आएगा, माली आएगा, कट करेगा. You keep delaying it, and all of a sudden the monsoon comes. Thunder showers are there. This tree, is affected, and in one of the thunder showers, the tree breaks down. Your neighbor has just bought his brand new Mercedes Benz, and the entire tree falls on the Mercedes Benz. And the Mercedes Benz is now in two portions. Mercedes Benz. You getting it? दो टुकड़े हो गए उसके. So can you take act of God as a defense? Can you say कि भगवान ने तोड़ा है तुम्हारा Mercedes Benz? Can you say that? No, because this is something which you could have avoided. You getting it? In case the rains were unprecedented and all of a sudden a flood would have come, and your car in flood would have literally बहता हुआ जाके सीधे उनकी Mercedes में मार देता. That is something which is called as act of God. Something which we could not foresee, something where there was no human interference, where extraordinary natural forces were there, extraordinary by the standard of that particular place, or extraordinary by the standard of that it never happened, etc., etc. These things, and that is exactly what we call as act of God. You getting it? I hope it is clear, the act of God. So you have to remember one thing: act of God. There is a Latin terminology for it, which is called as vis major. Now, AILED has a habit of asking you Latin terms and all, So you have to remember that act of God also means vis major. Okay. Okay. Someone is asking me, but someone has not asked him to cut his trees, or he was unaware of it. No. See, if someone has not asked him to his trees, or he was unaware of it, don't you think he had a duty of care towards it? That he should have known he is dealing with a substance. He, in his control, has a property, you can say a big tree. Don't you think he should have been aware? He should have an idea that, okay, this thing is happening. For example, if I have a dog, this is a ferocious dog, I know it. You're getting it? I have to take extra care of it कि कहीं मुझे छूट ना जाए. All of a sudden it doesn't, it breaks open the chain and goes and, bites people. What did that person who has just been bitten do? You're getting it? What is his issue? If I am dealing with that dangerous substance, I have to take care of it. I cannot escape liability by just saying कि I was unaware of it. अच्छा, मेरा कुत्ता इतना डरावना है, मुझे नहीं पता था. ऐसा नहीं होता, ठीक है? So I have to. So if I have a tree, I have to take responsibility. I have to take, a responsibility of it. Now, if it trimmed, but it still fell. Now, scientifically, if you trim a tree, it doesn't fall. But if you have trimmed it, like कंजूसी दिखा दी तुमने और अच्छे से नहीं किया, and then if it fell, even then you are liable, because you have to see to it that your property doesn't go ahead and injure people. You're getting it? So if he had trimmed, even if it fell, you cannot say कि नहीं मैंने इतना तो करा था फिर भी गिर गया मेरी गलती नहीं है. No. If that could have been avoided, you should have tried to avoid it. But if it was an unprecedented incident, you can just read it. You know, extraordinary occurrences of natural force. That is exactly what we are referring to here. That means extraordinary matlab he had trimmed it, but the rain was such, the thunder showers were such that all of a sudden it break open and it fell. You're getting it? So that is what we are referring to. These have to be extraordinary things. That is why हमने भगवान को इसीलिए तो involve किया है. You know, that is his power. He is extraordinary. So if extraordinary things happen, only then you say that it's act of God. Now, if he gave a contract to someone and he does not do it, see, now this is something which you are going off. Okay. Now, if he gave a contract to someone, he might have done anything, but he should have got it done. Because any neighbor of mine should not suffer because of me. You getting it? Any person should not suffer because of me. For example, you know, if I have asked him to do it and he did not do it, what was I doing? Because the rains are about to come. You getting it? So it's my duty to do it. Because through my act, I had to, you know, if I am not doing my duty and if someone gets injured, I will be held liable for it. Okay? So let's move ahead. Yeah, this is the question now. Let's go through it and give me an answer. So Parth and Dheeraj are very quick. Guys, please when you answer, take a bit of time, read it very carefully, you know. At times when we jump to questions, because legal reasoning questions have that kind of a thing, कि हमें बड़ा अच्छा लगता है, तो हम फटाक से jump करते हैं. So that should not happen here. A. Okay, maximum number of you think it's A. The IMD, that is the Indian Meteorological Department, predicts heavy rainfall in the coastal town of Hebri near Manipal, but true to this reputation or lack of it, it fails to predict cyclonic rainfall. As a result of this, the entire town is inundated and most houses sustain a lot of damage. Mr. Naik, social worker, sues the Hebri Nagar Panchayat for not warning the residents and taking sufficient precautions. Now, can he be held liable? Many of you also saying it's C, that cannot take the defense since it was aware of the possibility of heavy rainfall. While, okay, we also have someone who says B or C, I'm not sure. Okay, so A says can take the act of defense, cannot take the defense since it should have been foreseen such damage in view of the well-known inability of the IMD to predict such things. C says what we have just discussed, Mr. Mack cannot bring an action on behalf of the entire town. Anyone who thinks it's D? I did not find anyone who thinks D. Okay, it's not an answer, so you know you need not say it's D. So the answer is between A, B, and C. Yep. So A, B, maximum guys are saying A, B. Okay, guys, the correct answer here is, the correct answer here is B. Again, why B? Now let me tell you the answer. The simple reason is, if you read it carefully, cannot take the defense since it should not have foreseen. It should have foreseen such damage in view of the well-known inability of the IMD to predict such things. Because what is IMD? It's basically, say a meteorological department. Now, it's a meteorological department which is basically looking into such kind of a thing. But if case, oh, I'm so sorry. It's not. The answer is not B. The answer is A. Okay, I just read it wrong. The answer is A. It's not B. So a small correction here. The answer is A. They can take the defense of act of God, because if you read it carefully, it failed to predict cyclonic rainfall. The word used here is it failed to take the to predict the rainfall. Now, if you go through the the principle, it says if an injury is caused by the effect of natural forces and the natural forces are unforeseen or the effects are unavoidable. Unforeseen means They could not predict it. You getting it? Now, cyclonic rainfalls are as such that you cannot predict them. You're getting it? It all of a sudden comes up. Now, they could predict heavy rainfall, and they did tell people that this is how it is going to be, but they could not predict that it is going to be on such a large scale. You're getting it? And that is exactly what act of God is all about. If you read the principle carefully, it says they are unforeseen or the effects are unavoidable. You're getting it? That is exactly why HNP can take the defense of act of God. Okay. So IMD can predict how can the panchayat for sure. It's very simple, because a panchayat can be held liable for a particular thing. Now panchayat is being sued, but again, can they predict all these things? You getting it? Can they? Are they the ones who have to? Because IMD was the one who told them that this is going to happen. But could they predict it? They cannot be. Can IMD be sued? No, because even they could not, because that was something which they even failed to. Had they been able to predict it and they had not told the people, then they can be sued. They could predict that, okay, a rainfall is about to be there, but they keep quiet. But you won't believe it. I also have a classic case which happened in Mumbai, where the meteorological department in Mumbai, they knew. If you remember, there was a flood in Mumbai, a few years back. And in that case, they knew, they predicted, but they did not tell the people. When they were sued, they had a very classic defense where they came and said that we are talking about Mumbai, and in case if we had predicted and we had informed people, more number of people would have died, more number of people would have died in the flood, in stampede, because Mumbai, it's like it's such a crowded place. So more number of people would have died out of stampede than that of the floods, and that was something which was taken very seriously, or else as a valid argument by the courts also. They said you are right. In case if we would have informed, people would have started say running hither and thither, and they would have killed many more people. That was a kind of a defense, and then again it was seen as an act of God. Okay, moving further. Now, act of private defense, one of those defenses which is, which can be used by a person, where a person can, go ahead and even it can be used to such an extent where he can go and, even kill people in his own private defense. But believe me, there is a particular rationale before using act of private defense. So what is that rationale? Just read it. If the defendant uses the force which is necessary for his self-defense, he will not be liable for the harm caused thereby. Use of force which is necessary is reasonable force. Justification for the use of force is imminent threat. Two of the most important things should be discussed here. The first thing is, you can use private defense as a reasonable force. That means it should be a reaction to an opposite action which is coming in your way. And it should be very reasonable. You getting it? So in case if you are standing with a gun in your hand and if a huge crowd is running towards you, what should you do? Should you start firing at people? No, you cannot. What is the best option available to you as per the law? The best option available to you as per the law is, if you can run for your life. You getting it? You can, you can go ahead and start running here and there because you want to save. In case if you are surrounded, you cannot go anywhere. Then only you can start firing. But the first fire should be in the air. You have to caution people. You have to say, see, I have a gun. But still if they are coming, then again, you cannot directly shoot people on their head or, anywhere. You have to first shoot the people below their knee. Again, that is exactly what is called as a reasonable force. And still if they are moving in your direction, then, you can probably shoot some people down. Reasonable force. The rationale is quite simple, I'll tell you. It's like, if घर पे चूहा निकला हुआ है, the rationale says कि you cannot go ahead and have a AK-47 and say कि मारो चूहे को पकड़ के गोली चलाओ, पड़. You cannot do that. So, whatever the kind of a threat you are facing, your reaction should be very proportional. The proportionate force has to be used from your end. Only then you can call it as a reasonable force. So the second thing is, there should be an imminent threat. When I say imminent threat, the threat should not end. It should keep on continuing. So if you remember, I said the entire crowd is coming towards me. I fire in the air and they start retreating back. I should stop. I should not say, अच्छा भागोगे, मेरे को मारने आए थे, and then I start shooting them. I cannot do that. You getting it? So in case if they start retreating back, it means that the threat is not imminent. Threat has ended. You getting it? So that is how it goes. Two things very important. The first is that the particular force which you are using should be reasonable, should be proportionate to the kind of harm which which is going to happen on you. The other thing is the threat should be imminent. It means that it should not it should be continuing in nature. So if you are going from somewhere and all of a sudden the person comes and snatches your bag away and starts running, if you run behind him, you pull out your gun and you say, I have a gun, I can shoot you, and the person throws your bag somewhere and he says कि ले पकड़, तुम्हारे पास gun है, this is your bag, let me go, and he starts running. You cannot go ahead and shoot him because the danger ends the moment he throws your bag off. Agreed? Even if he's running, he's a thief, you can call up the police, you can inform them, you can go ahead and kill the person. Use of force, the tricky area is use of force not warranted. That means if in case you could have avoided using that, you should have avoided it. Use of excessive force, you cannot go ahead and use some kind of a excessive force. If a person is coming to you and he's saying, I'll kill you, before today evening I'm going to kill you, and he walks out, you cannot say he said he's going to kill me before the evening, so I shot him down. Right? You could have called public authorities. You could have called up the police and said, this guy, if he comes to kill me, then I'll have to kill him. Before that, please arrest him. You getting it? So that is how the Act of Private Defense goes. Now, there are some questions where they are saying why there is no self-defense against self-defense. It's very simple. If you are running into a person's house with a sword and you want to kill him, and in his defense he pulls out a gun, you cannot go ahead and kill him and say कि नहीं वो मुझे मारने वाला था. In the first place, you yourself are doing wrong. Now, why did you go and try to kill him? And he was acting in self-defense. Getting it? So there is no self-defense against a self-defense. Okay. Now, can I kill a person who was about to kill someone? Yes, but then you have to prove that he would have killed him in all probability, and killing him was the only option available to you. In case you would have avoided it, you could have jumped on him, tried to tie him. In that sense, you could have if you kill that person, you can be prosecuted. But killing him should be the last option available to you. You can just read it. It should be imminent threat, and killing him should have been the most reasonable force which you did. If any robber is coming to hit me and in panic I shoot him, will I again repeat, guys, hear me loud and clear. If anything is happening, okay, and killing that person was the last option available to you, because this is not an answer which you have to give it to me, but on the other hand, killing is something which you will have to explain it in front of the judge. The judge is going to question you like anything. And he's going to ask you, was killing the only option available to you? The prosecution is not going to leave you. They're going to say, no, sir, this guy is a notorious guy. The person should not have been killed. Now, come on, guys. We live in a country where, armed personals, the shootout specialists, they have to account in front of the agencies that killing was the only last option available to us, even when it comes to a dreaded terrorist. Again, United States of America had to give explanations that why they had to kill Osama bin Laden. Remember that? What was the rationale they gave? That was there were people who were asking the United States of America, why did you kill his wife? Then United States of America said, hello, his wives were also shooting on us. Remember that? So that is the rationale here. So lots of questions are coming up as to what is meant by reasonable and how to identify a reasonable act. My dear Pranav, it's very simple. Reasonable means there has to be a reason behind it. You getting it? Now, reason differs from action to action. So if we are talking about private defense, what was the reason behind you killing him? Because this person was on top of me, he had a knife in his hand and he was going to stab me. I had no other option, I had only a gun in my hand and I had to shoot him. And on the other hand, I pushed him. He picked up the knife and he started running. And I was like, nahi, isne mujhe marne ki koshish kaise kari? And I shoot him. Do you think that is reasonable? So, reason is something like that. Again, necessity versus private defense, it's a big difference. The difference between self and private defense. Private defense as a whole is a genre. You getting it? Under private defense, it doesn't mean that it is only for my defense. I can also use private defense for the defense of another person. So, just think about it like you are in a village, a typical Sholay kind of a village. You're getting it? And in there, a group of dacoits attack, and they start carrying a female. You know, they're kidnapping a female और उसको लेके जा रहे हैं. All of a sudden, you see a 303, rifle lying over there. You pick it up and you want to basically shoot the dacoit. But when you shoot, the bullet goes and hits the female, and she dies. The dacoit also leaves the girl. Dead body लेके मैं क्या करूँगा? छोड़ो इसको. So did you commit the murder of that girl? You acted in private defense because you wanted to save her, but somehow the bullet went and hit her. Did you do a reasonable act? Yes, that was the act which you could have done. But yes, the police is going to ask, or the prosecutor is going to ask, why didn't you shoot at the horse? क्योंकि लड़की थी, डाकू इतना सा, घोड़ा इतना बड़ा, तुमने क्यों नहीं चलाया? What could be the reasonable argument here? You can say, sir, I am not a professional shooter. I just wanted to save her, but it's something which can be called an inevitable accident. You getting it? So that is exactly how it goes. Now all these questions, as I said, I'll take it at the last. So you just mark these questions and ask me at the end of it. Okay? So we are already running out of time, so I'll go ahead and finish it off. Act of private defense, I hope it is clear to you. So there's a problem which you have here. Can we solve it? Actually, this question is not at all readable. So what I'll do is I'll just skip it. Okay, you'll get these things. Even I cannot read it because there is a lot of overlapping here. Okay, Harshad could read it. Harshad, you are a genius guy. Okay, so what we'll do is we'll just skip this question. You get lots of questions on your SIS, and then you can solve it. You just need to understand this thing. And okay, let me ask you a question. Because we're leaving this question, let me ask you a question, and you guys can just shoot your answers to me. My question goes something like this: that just think about that Osama bin Laden is not dead. Okay, so the question goes something like this: that you're sitting in a mall, you're having your pizza. Just then you realize that the person who's just sitting beside you is Osama bin Laden. Right? And you're like, my goodness. You look at him. What he is doing is, he's sitting there and he's having his kebab. You getting it? He's eating his kebab and he's saying, Wallah, lazeez hai bhai, lazeez hai. And he's enjoying his kebab. Now, all of a sudden you realize that this person has a wanted dead or alive, tag on his head. And you're like, my goodness. You look here and there, but none of the people around there are able to recognize him that he's Osama bin Laden. You getting it? Now you are like, my goodness, what should I do? All of a sudden, you pick up a fork, you just land over him, you land over him, and you go ahead and, with that fork, you stab him 7 times, pat. You kill him. And then you get up, the people start screaming, and you're like, don't worry, Osama bin Laden for you. Did you act in private defense? Yes. My question is, did you act in private defense? No, not at all, not at all. Wow. What's your reason, guys? So that means maximum number of you have understood private defense well. Yes, exactly. You did not act in private defense. Now, why I can call the cops? Good. There is no imminent danger. Oh, wow, guys. You guys are smart students. Yes, wow, what an answering. I am enjoying this. Great. Very right. Because what was that poor guy doing? He was having his kebabs. Yes, as Anvisha said, he was poor thing. He was just having his kebabs. He was not hurting anyone. He was not causing any kind of a danger to anyone. You getting it? So, whatever he did was not something which can be classified as an imminent threat. Yeah, awesome. Okay, let him eat in peace. Okay, do not get him arrested, Damini. What do you think? Yeah, what you could have done is, the most proportionate reaction would have been, you should have surreptitiously, you should have gone and, you should have called up the the police, and you should have called the cop and said, okay, we have Osama bin Laden here. Now, if I change the facts a bit, if I change the facts a bit, and if I ask you that when you took a look at him, he was not having his kebab. You getting it? What he was doing was, time and time again, he was placing his hand inside a bag, and he was, looking here and there. In a very surreptitious manner, he was looking here and there. And he was looking very, very confused, or else he was looking, very, what you say, as if, he's conspiring something. You get me? Now, had you done this thing then, and had you, killed him with a fork, if I change the facts like this, what do you think? Then would it have been a private defense? No. Okay. If you say a no, tell me a reason also. Why no? Still no imminent threat. What if, inside the bag he had a bomb? This guy, sitting in Afghanistan, he could blow the Twin Towers. Okay, now I get some yes. I didn't see it. You never know. Okay, now the house is divided. Some guys are saying yes, others are saying no. Great. Call cop. He's a proclaimed criminal. Repeating the question, please. It's very simple. The same set of question. I just changed the facts. But when I looked at him, he was not eating his kebabs. On the other hand, he was surreptitiously looking here and there, and he was placing his hand inside his bag. And time again, he was opening his bag and looking here and there. Then no. Okay. There is no direct threat. Killing is the last option. That is what Suman feels. Yes, guys. What do you guys think? Osama bin Laden, come on. Now, guys, had I done this, I'll have to answer, like we said, I'll have to answer that killing was the last thing which I wanted, and then I can say he's a wanted criminal. And his actions were as such that I thought inside the bag there was a bomb. The danger was imminent. He could have, killed so many people. We were risking so many lives there. You're getting it? And moreover, there's a wanted, dead or alive, tag on him. And God knows what he was up to there. You're getting it? And on the other hand, in the first, as we said, he was just having his pizzas. You could say, "Okay, yaar, chalta hai," because, us time, you could have just caught him. You're getting it? Still no physical action can be taken. See, if he was any other person, for example, if you remember, in the case of Kasab also, there were people who were trying to catch him, but then he was also shooting here and there. If you remember, there was one police officer who lost his life while catching Kasab. So these kind of people, they are wanted dead or alive just because, they are more dangerous to us. So if there is an apprehension on our part that this person can kill another people and we do not have time. For example, if he was sitting and if he was having his kebab, I could have went, rather than calling the police, I could have went and I could have gathered a crowd and said, "Ki boss, you know who this guy is? He's Osama bin Laden, let's catch him." And then I could have, used the help of people even before police comes. But here, I don't know. He has a bag in his hand. Maybe there is a bomb inside there. You getting it? And he could have just blown off the entire mall or wherever you were sitting and having your pizza. So you have an apprehension there. You getting it? That he can get people killed. You getting it? So that's why in this case, if you have full confidence that he's Osama bin Laden and his actions were as such, there's an imminent threat, you can go ahead and you can use private defense. Okay, so that is basically the answer to it. Okay, Rishika, that's an assumption. See, most of the questions which you will receive in CLAT, you cannot question the question. Okay, you getting it? You have to follow the principle. I again repeat, that is exactly what most of the students do, and that's why they don't score. You getting it? You start questioning it. You are good at arguing. I am very happy. But the thing is, when you are asked a question, you have to stick to the principle and say, okay, A, B, C. Okay, A, B, C are matching. That's the answer. You get it? Now, mistake, another defense of law. Now, in law of contracts, they say that mistake is something which is of two types. One, mistake of fact, the other is mistake of law. You getting it? So, mistake of law is something which is never excused. You getting it? Mistake of law can never be excused. There is a Latin maxim also which supports it, which says, ignorantia juris non exusat. Okay? These things are given in the module, so you can just go through them once and you'll get it. Ignorantia juris non exusat. It means ignorance of law cannot be excused. That means mistake of law cannot be excused. But here we're going to talk about mistake of fact. It means under a mistake. When I say mistake, it means a genuine mistake. Something somewhere where you had all proof to prove that you were right. For example, your neighbor, from your neighborhood, you hear creatures coming, as you know, there are people who are screaming, and there's a female who's screaming, help, help, help. You jump to, to the neighborhood, you press the bell, but there is no response which is coming from inside. In fact, the voice starts increasing, and the volume starts increasing, and you're like, my God, there's a problem. You just bump into, you darwaza tod ke full filmy style mein, you get inside and you see that these guys are actually watching a movie, So what is this? This is called as a mistake of fact, But for this, you have to explain that when you did this, you did press the bell. You getting it? You did raise caution. But these guys are at mistake because they were not listening to you. You getting it? Such is mistake. Now believe me, mistake is the weakest of the defenses. When we say general defenses, mistakes are the most weakest defense ever. Why the weakest defense? Because, as I said, the other name of mistake is called as negligence. You getting it? So the mistake of fact has to be a genuine mistake. You getting it? And if it was a genuine mistake, all fair. Getting it? So that is mistake for you. Now, necessity and statutory authority. Necessity. Let's understand necessity first. What do you understand by necessity? What is the meaning of the word necessity? Something which does not have an alternative. You get it? Something which does not have an alternative is called as necessity. Very necessary. So very necessary for life. For example, if I ask you what is necessary, what is necessity, you would say food, clothing, shelter, internet. Is that a necessity? What do you guys say? Some of you would say yes, it is. But as of now, I can say that slowly it is becoming a necessity. Yeah, the opinion is divided because still in our country, it has not become something which, as a matter of right, has become a necessity. As of now, it is yes. Someone saying right because to conduct the session, internet is yes, right. So necessity basically considers those things which are the most important. For example, if we say necessity as to conduct this event, yes, why not? You're getting it? Without this, we could not have got connected. So in a particular scenario, if a person goes ahead and commits a act, you cannot call it as a necessity unless until he did it because he had no other option to do it. You getting it? That is what you call as necessity. So let me ask you another question other than following the module question. Let me ask you a question and you have to answer it to me. Okay. So when you say a yes or a no, please give me your, reasons also. Just don't give me a yes. Yeah. So let me ask you a question. You are going out of you're just walking down the lane and you see that before a house, a Lamborghini Murcielago has been parked. You getting it? And you start looking at it and you're admiring it. You're like, wow, yeah, what a car this is. All of a sudden, you hear shrieks coming out of that house. There's someone screaming, help, help, help. You run into the house. And the first scene that you see is there's a 80-year-old man who's suffering from a stroke. You getting it? He's getting a heart attack. And his wife is saying, please take him to the hospital. Now, you grab him and you start dragging him outside. His wife comes from behind and she says, alto ki chabi le jao beta, isko le jao. And you are like, nahi, samne, Lamborghini khadi hai. You pick the person, take him into the Lamborghini and just fly off. उसको लेके एकदम भाग जाते हो तुम. पीछे से बेचारा the owner of the Lamborghini, he starts saying, अरे मेरी गाड़ी छोड़ दो, and you go with the Lamborghini and you make sure that the person reaches the hospital on time. So did you act, or else this particular incident, can you say it was necessity? You acted in necessity? Yeah, what is your answer? Yes, very simple. There were people who had given me reasons also. That is exactly the reason, that he had an option available. You're getting it? Now, can he say that an Alto would have taken time to reach the hospital? So Lamborghini made sure that I reached on time. Can he say that? Can he say because Lamborghini has a better speed, so we could just fly into the hospital? Yeah, true. I'm so happy. You guys are understanding everything. Yes. Okay. Someone is saying, Pranav is saying maybe. There's no maybe in law. There is either a yes or a no. The answer has to be no, because if there was any alternative, you have to be very clear about it, that you can, you had to do it. Again, you cannot infringe the right of another person just because you think that it is necessary. Again, the other is statutory authority. Now, statutory authority means a particular body, a government body, which has been given the power by a statute to conduct something. So you cannot file a case against a statutory authority just because an injury has been committed on you because they were following a particular statutory function. For example, let me give you an example. Statutory authority. They are the ones. So what is the answer? I've already given the answer, Janvi. The answer is no. It was not necessity. There will be a case which will be filed against you. The person would say he committed a nuisance on my property, and then he took away my property, my Lamborghini, and that's the answer. You cannot take up the defense of necessity. Okay. The next, the defense was statutory authority, where I say there will be a statute through which people derive authority, and in the discourse of that particular authority, if they infringe your right, you do not have a cause of action. So people from Delhi and people from Bengaluru would understand this, because when the Delhi metro or a Bengaluru metro was about to be constructed, there were many structures which were just demolished off. Why? Because Metro Corporation was a statutory authority. In case if your house was in the way of it, the statutory authority would come, serve you with a notice and say vacate it, and you will be given compensation as per the government rates, because they can do it. They are the statutory authority. If they raise the entire structure, they are doing it for larger public good. So statutory authority goes like this. Now I'll give you another example. Some people are protesting. They're protesting against the government. They have all the right to do it. But all of a sudden, they start, going violent. The statutory authority, who is the collector, he declares that disperse these guys, declare their assembly as unlawful, and if need be, also go ahead and lathi charge them. Now, all of a sudden, you are standing there, the police walas come, who are the executive authority, who are going to execute the statute. They come and they announce, kindly disperse, kindly run away from here, because we are going to lathi charge you. Your association is now being declared as illegal. You are very excited. You have never seen a lathi charge. You are like, maza aayega, chalo lathi charge dekhte. All of a sudden, the lathi charge starts. Okay? And people start running here and there. You were not a part of that unlawful assembly, but who were you? You are just standing there and you are just looking, maza aa raha hai. Just then a police wala comes and tumhari pitai kar deta hai. He starts, giving, and you are like, "Arey uncle, mujhe kyun maar rahe ho?" Can you go ahead and file a case against the police walas? Can you? Yes. The answer is no. Again, why? Because he is functioning under that particular statute. Again, the kind of activity or the kind of function which he is doing, he has a statute behind it. Now you are someone, if you get hit because you were standing there, that's not his problem. The moment he announced that kindly disperse, even you were a part of it. Whatever you were doing it, whatever you were doing standing there, if he was going ahead and he was fulfilling his functions, that is something which as a power has been given to him by the statute. Getting it? So that is the answer to it. So these are the two defenses. First is necessity and statutory authority. Sovereign authority, statutory authority are more or less the same thing. Sovereign authority specifically means sovereign is a government. Statutory authority, the sovereign creates a statute and gives that statute to a and gives that authority to a statute. Okay. So moving ahead. So there are some problems. You can just solve it and give me an answer. Okay, the term thinks it's C. C. Ankur, a law-abiding citizen, decides to remove the weed of corruption from the Indian society. One day, confronted with a bribing official, Ankur decides to teach him a lesson and punch him on his nose. The official has filed a suit against him. Will he succeed? The answer is plain and simple, C, because that was not something which he should have done. The person belongs to a statutory authority and there are statutory authorities which can deal with him. Right? That was not necessary. Yeah. So thank you so much, and now it's time for you to ask me questions relating to today's session. Any kind of a question, kindly write it down in a single line and ask me. Okay, I'm waiting for your responses. Yeah, please, your questions. And as I said, a single message should be typed. You should not go for multiple messages. A single question and a single, a message. Yep, I'm waiting for your questions. The state will not do a non-sovereign function. Getting it? If a state is doing it, it has to be a sovereign function. But let me tell you something else, Pranav. If the state is misusing sovereign functions, or if a person is misusing sovereign functions, the person can be sued. The state cannot be sued. You getting it? The state can be sued for doing something where it infringes your right, for which you go to the judiciary. You have a writ jurisdiction for it, right? But in case if some person is misusing because government can not do any kind of a wrong, because the government as such is not a person. It is an agency. You realize that? But if there is a person who is delegating the sovereign functions and misuses it, there can be a case which can be filed against him. So I'll give you an example also. Just think about it, that in case there is a police wala, like in the last case, what was he doing? He was doing something which is a non-sovereign function. And if he is doing that, you cannot accuse the government. On the other hand, you can report to the government that someone under you is doing something which is disqualified as a non-sovereign function. So you can file a case against him before the government itself, because government is the one who has to act. You getting it? So that is how it goes. Now, we are not supposed to conclude or assume facts from the data given in the question. Yes, you are totally right, Shubhra. We are not supposed to conclude or assume facts. You have to stick to the facts. You have to interpret the principle which is given to you. A, B, C, D. As I said, break down the facts. A, B, C, D, and search for those things in the facts. That's it. Cannot assume something. Do not assume something. Just say, this is my answer. Blah. Khatam. Right? I find torts easy. Is it good or my overconfidence? I would say torts is actually easy. Torts is plain common sense. Now, the moment we start with contract, you'll realize that things are not easy, because contract is based upon the principles of equity, and that is not something which is very easy to digest. But then you'll live it, because that is something again which is very interesting, because if you want to do corporate law, contract law is something which you should. So torts is, again, I said when I started with the session, I said torts is all about common sense. Whatever we discuss something today, private defense, common sense here, बहुत easy है. And if I defend myself and if I do it in a better manner, so it's easy. So don't think that it's overconfidence, because the questions which we are solving, the professors of National Law School, they are very good in confusing you. So solve more and more questions and feel that it's not easy, but yes, if you compare it with any other branch of law, it is easy. Now, what can actually come under legal right? It's very simple. Legal right means anything for which a law gives you a force. You're getting it? There's a force of law behind it. That becomes a legal right. Simple. But it should be written down somewhere. Only then it becomes a legal right. One of your legal right is getting maintained by your parent. You're getting it? They're paying your fees. They're taking care of you. They are all legal rights. They are not specifically written down somewhere. But yes, it is a legal right for you to be maintained by your parent. Is the principle of mistake same in tort and contract? It is same. It is very much same. But tort means, as I said, civil wrong. In contract, there will be some rights and duties which you have exchanged. You getting it? So contract is entirely upon that particular relationship which you have. And on the other hand, tort law is universal. Tort law is general acceptable things. And on the other hand, contract is acceptable in terms of what you have discussed. Nothing else. It has to be written down. A will do this for B. So, the mistake has to be related to that. Nothing else. You get it? So it's more or less the same. How to know if someone has statutory authority over something? It's very simple. He is doing that job. He has been empowered by the government. For example, a police wala, he has every right to arrest you. And it depends upon the bailable case or a non-bailable case. You getting it? So that is how it goes. So if in the question it will be given to you that the person is statutory authority. I have not understood the difference between act and omission in tort. Please explain with example. Okay, Rishika, it's very simple. Act means inside my house, whatever I am consuming, the wastage, I am going and throwing it in my neighbor's space. You getting it? So what am I doing? I am acting. On the other hand, omission means all those garbage I'm not throwing anywhere. I'm dumping it in my own yard. And that starts thinking. So what am I doing? I am omitting, as in I am not cleaning things inside my house. And they start stinking. And that foul smell goes and escapes and reaches out to their house. So I can say कि मैं नहीं कर रहा हूँ यार, उससे तुम्हारा क्या जा रहा है? मेरी मर्जी, मेरा घर है. But that foul smell is reaching them. You getting it? I'm omitting to do something. Even that can be a tort, because they have a right to remain inside their house, and such kind of things, if it is escaping out of my house and if it is bothering them, even that will be something where omission can have a lot of effect. You getting it? So Rishika, I hope you have got it. Can we conclude an answer by applying multiple principles? If it is given there, yes. If the principles are given there for that question, you can conclude. Otherwise, if it is not given there, for example, a principle given in question number 21 is immaterial in question number 23. You getting it? In 21 itself, if there are 3 principles, you can apply it. What is the difference between private defense in tort and private defense in criminal law? The same rationale is there. Tort, again, it's simple. It's about your own, life. So, that is how your own civil right, while on the other hand, criminal law, we have already discussed that what is criminal law. So, the same rationale is there. The rationale applied is very same, that, it has to be a proportionate force which you use. So, the same principle applies there. So, we'll do it when we'll do criminal law. Don't worry about it. I hope you have just understood what we have, read about tort. Vicarious liability and all, my dear Avantika, what we're going to do is next class is upon this. So we'll be discussing about liability, vicarious liability, strict liability, absolute liability. So that is in the next class. So don't worry. We'll surely do it. Don't worry about it. Up to what extent principal is liable for torts committed by agent? My God, I am so happy that you all have read all these things, but we have not discussed those things. So the other students who are here will be petrified, and we have not taught it. So we cannot go ahead and start discussing these things. So we'll discuss that. The way I have explained it to you, I hope you have understood it in the same way. In the next class also, what we'll do is we'll understand all these principles. Okay. The examples of legal right, I've already told you, your right of getting maintained by your, parent is called as a legal right. Again, it is explained, it is written down in various acts. Now, all those various acts makes your legal right. Your parents also have a legal right from your end to be maintained when you will start earning. You have to maintain them. That's their legal right. The person is arrested and his jewelry is taken after release on police. Okay, this is a true case, Vedant, and this happened, in that case when the guy who took the police officer, when he took the gold and ran away, is committed an offense against the state also, because that was in the state's custody. The state will, on the other hand, say, we were here to decide the case, this guy cheated us also. We are going to file a case against him. But in this case, in the true case, this guy took the jewelry and flew to Pakistan. So he was outside the jurisdiction of India, and moreover, the Indian-Pakistan relationship were as bad as as of now. So nothing could have been done. There is a terrorist who had threatened a person and instantly killed him. Now he has threatened me. Though he doesn't have a gun in his hand, no, you cannot shoot him because simple logic. Abhi tumne hi to answer diya tha, Shubhra. You said, imminent threat. So my question here is, was there imminent threat? He killed him, but he is not harming you. You yourself are saying that he had no gun in his hand. So how can he kill you? You getting it? So you cannot go ahead and kill him. And on the other hand, if he has killed that person, before killing him, if you could have saved him, after killing him, you cannot do it. You have to just wait for it. You getting it? But in case he killed him and he's about to point and kill someone else, you go ahead and kill him. That is something which you can do it. Right? Difference between battery and assault, my dear Anubhuti, we will be studying this in the next class. That is a topic which we are going to cover, battery and assault. So please hold on. Again, can we assume certain things, or we should just stick with the principle again? Rishika, no, you cannot. Whatever is given in the principle. As I said, when you read the principle, break it down. A, B, C. And those A, B, C is something which you have to, look into the facts. Look into the facts and say, "Acha, ye ho raha hai, imminent threat hai, ho raha hai. Ye ho raha hai, ye ho raha hai." That's it. That is what legal reasoning is all about. It's not about assuming, because if the power of assumption is given to you guys, you can just assume anything. You getting it? We all become Sherlock Holmes and James Bond. बहुत भयंकर चीजें सोचने लगते हैं हम. So please, no. But it's the meaning of state in both. What is the meaning of state both in crimes and thought? I don't get it, Raghavendra. What do you mean? What is the meaning of this state both in crimes, state, and thoughts? I don't get you. Can you be a bit more illustrative? Now, Akshita, I said in the question of Laurie, Akshita, I had requested you that if you have a question, please write it full in a message. I am not answering that. A terrorist in entering a crowd, can we assume that he's a suicide bomber? No, you cannot assume. You just cannot assume. But if it is written that, we were talking about legal reasoning questions. Okay, so if it is written down there, a suicide bomber terrorist enters, only then you can assume. You cannot just assume. Or else in the fact, if it is given, a terrorist enters and he starts looking like a suicide bomber. Like, when we were discussing that Osama bin Laden case, I told you that he was looking surreptitiously here and there. So time and time again, he had a bag in his hand. Now that is the demeanor through which you can assume that, okay, this guy is going to do something because he's already done that. Right? Reasonable overuse of private defense is allowed or not, as in situation it is difficult to calculate proportion. See, reasonable overuse of private defense, as I said, it has to be something which is justified in the hands of law. For example, you are standing, you're playing cricket with your friends, and all of a sudden the most ferocious dog of the colony, is out. All your friends run away. You're just standing there with a bat in your hand. It starts coming towards you. In front of your eyes, it has already, bit auntie, uncle, and now it's proceeding towards you. You have a bat in your hand. In mad rage, you start charging towards the dog, and then it starts retreating. Can you go ahead and hit it? That is exactly what you are saying. Reasonable overuse of private defense. Because the moment the dog starts retreating back, you cannot go and hit it. But you are like, नहीं मैं तो मारूंगा इसको जाके, ये मेरी तरफ घुर्राता हुआ कैसे जाए? You go and hit the poor thing so badly, उसका spinal cord तोड़ दिया तुमने. Can you do that? Is it something which is private defense? It is not. You getting it? So that is overuse. That is what law says. It should be a main threat. It should be a continuing threat. You getting it? What written? Akshita, you're not making any sense. No, I told you, if there is a question, please, in a single message, please type it. You know, it's like what written in manual, not in law. I am not getting it. I'm so sorry. What can be assumed when the word state is seen? Is it a government or... See, the word state basically means many things. It can be government, it can be police, you know, the entire circle. The entire circle where, you know, it can be a municipal corporation, it can be, you know, a taxation official. All of them are seen as state. Okay, Raghavin, I presume you have understood it. Now, how many tort questions will come in CLAT 17? My God, Pranav, had I known that the answer to it, I would have answered it just now. And I would have made sure that mera har bachcha ye, you know, had an idea कि कितने questions आएंगे. But as a guess figure, I would say, you know, you can expect minimum. I can give you a minimum rank. You can expect a minimum of around 8 questions. You know, one question shall surely come from vicarious liability. Because each year there is a question from vicarious liability. So that is why we have a separate session for vicarious liability in the next class. Okay, so I cannot give you a figure. I cannot fool you. You know, there are people who do that on the internet. I'm not one of them. I cannot just specifically take it. No, pakka fega. No, I'm sorry. But minimum 8 questions would come, and vicarious liability 100% is going to be a question. In the question of lorry, what was written in the manual, not a law? What? In the question of lorry, what was written in manual, not a law? If anyone is able to understand what Akshita is saying, can you just explain it to me? Because I am not able to understand her. A person looking for his son looks here and there and in anxiety here and there. I think he's a suicide bomber. Am I justified if I don't know he has lost his son? Minimay, I'll tell you one thing. If this is the case, in the legal reasoning question, that will be, you know, that will be specifically mentioned. You getting it? So what are you doing right now is called as assumption. You getting it? In case if it is mentioned like this, you have to assume that he is not a terrorist. Okay? Have you ever come across such kind of question? If you have to assume, the question shall tell you. You need not assume anything by your own. Okay? Now, a difference between right in rem and right in personam. Pranav, right in rem means a right which you enjoy with all others. For example, the right which you have over a public property is your right in rem. Right in personam is a right which you do not enjoy with anyone. For example, your right over your mobile phone. Getting it? Your right over your mobile phone is something which is your own personal thing which you do not enjoy with anyone. Make sense? Okay. So now, a tort law is the infringement of right in personam, but it says that right in personam should be, you know, acceptable in right in rem. So if you remember when I started, I told you guys that you know, you cannot celebrate Holi in England. Why? Because that is not a right in personam which is recognized in right in rem. Right? So that is how the logic goes. So that is the difference between right in rem and right in personam. Now, Anvesha says, Akshita is trying to say that in the question of the lorry, the law was written in a manual. The law was written in a manual. Yeah, that was a state law which was made, but that is not something which was given A, B, C, D. You know, remember, Akshita, you know, Anvesha is trying to help you. So if you remember, if that is exactly your question, you know, I told you that when you break down the principle, you have to watch for the principle. And that is why that answer was that. Otherwise, you know, practically, the person who is driving the lorry will be apprehended. He will be punished for that. That is a practical aspect of it. But you have to use the principle, right? The A, B, C, D, could you say that fell under what was in the principle? Akshita, I hope your answer is there. Thank you so much, Anvesha, for making sense of it. Okay, any more questions, guys? There will be more sessions of, you have enough sessions of legal. What we're going to do is we are also going to have more sessions of mathematics, more sessions of, logical reasoning, and that will be taken by the star faculties which we have. Shivku sir is going to take mathematics. Logical reasoning sessions will be taken by GP sir. Make sure you attend all those sessions, because this is our way to reach out to you, because we cannot be omnipresent. You're getting it? So this is an attempt by all of us, the faculties who are from our Delhi HO, to reach out to you and make sure that you all get to be taught by us. You're getting it? So make sure you attend those classes as well. You all know where to. Will that be free? Pranav, if you are interested, do show your interest. Our office is going to get in touch with you, and they're going to explain whether it is going to be free or not. Okay, I have one more question. It says in VNFI, in how many ways can a person give or express consent? As there in VNFI, how many ways can a person give? Yeah, see, it's very simple. Implied and express consent means if you are entering into, okay, in a mall you have this scary house, right? So when you are entering, it's quite obvious that it's a scary house. You're going to get scared. So there's a kind of a risk associated with it also. Now when you come out, you cannot say, "मेरे को mental shock हो गया भाई, अरे बाप रे, क्या डराते हैं ये लोग." Can you say that? That's the implied consent which you have given. You're getting it? Express consent is where it has to be expressly mentioned before you. You're getting it? These are the ways in which you can give it, and in most of the cases, the consent has to be taken expressly. Most of the cases. Now, in some very rare cases only, the consent is seen as implied. Ki haan yaar, itna to hota hai. For example, if you are consuming coffee, it has caffeine. You're getting it? But yet they write down that contains caffeine. You're getting it? And caffeine and its health hazards on you have to be known by you. You're getting it? So things are becoming more and more express. For example, smoking. You're getting it? Smoking, it's very simple. On the cover it is mentioned specifically, smoking is injurious to your health. So that is expressly mentioned to you. But do you, and I'm sorry, you don't smoke, but have you seen any person who smokes reading it and saying, "Oh, is that?" Even in the movies when they show it, they expressly show it, smoking is injurious to health. So people are trying to put things across, but it is also implied, which should it be again and again showed to you. So that is how it goes. Clear? So, these are the two ways in which it is given. Will this be uploaded on our SIS? Yes, this session will be uploaded on your SIS. So don't worry about it. So the initial, technical glitches have been taken care of. So now onwards, they will be totally taken care of because we have taken care of it. That doesn't happen. So in the last session, there were small issues which we faced. That was just because, people logged in much more than what we expected. So now, that problem won't be there. Will I get the lectures which I have missed? Will I get to see that? Yes, surely. That will be uploaded to your SIS. Don't worry. When is the next class? As I said, if you are interested, there will be feedback which will be taken from you. Then that all the info related to this will be given to you. Yeah. Anything related to today's class, guys? Because I can assure you one thing: there are going to be more online classes of mine because I have almost prepared, everything related to the topics which have to be covered, right from torts to say criminal law. Okay. It's a pleasure on our part. Thank you so much for attending this session. In fact, and you guys have been a wonderful audience. So together we have again caught Osama bin Laden and killed him today. Okay. Thank you so much, guys. I presume that's the end of today's session. Okay.